Are you in a situation where you may want to consider an alternative to formal probate? You may ask, is there any other way to do this than going through the formal probate process? If so, then this informational video may be just for you. Today, I'd like to share with you some alternatives to the formal Texas probate process. Now, this is different from avoiding the probate process. Alternatives to probate may be available if you're in a situation where you need to go through some form of probate, but not the entire formality of probate. By contrast, avoiding probate is different because that means that you have planned through proper estate planning to avoid the probate process altogether. Wouldn't it be nice if someone just handed you everything that you need to know about alternatives to probate? I get it. We both know that probate can be a complicated matter. The rules governing Texas probate can be found in the Texas Estates Code, and this seems to be changing all the time. You may ask, how am I supposed to know where to start? How will I know if I'm making the right decision? Well, if you focus on the 3 tips that I share with you today, you may be well on your way to finding an alternative to the formal probate process that is suitable for you. And that's good news. The more informed you are, the better choices you will make. So are you ready? Let's discuss some alternatives to probate. They are: first, there is a small estate affidavit. A small estate affidavit may be available to you as an alternative to formal probate if you do not have a will and the value of the estate is less than $75,000. Stay with me, and I will talk more about the small estate affidavit in more detail. Ammunitive title is another alternative to formal probate. Ammunitive title can be used as an alternative to probate where you do have a will and simply want to clear title to the home that was mentioned in the will. Yet a third alternative to formal probate in Texas is through a judicial determination of heirship. Although all 3 of these procedures do involve some type of court involvement, they are much less involved and cost less than formal probate. At the end of today's informational video, I will provide you with a link where you can obtain a free consultation to ask any question that you may have. Hello, I'm Jim Soto with the Soto Law Firm, a probate, guardianship, and estate planning law firm located in Houston, serving clients throughout Texas. You don't have to go through the legal process alone. My 25 years of experience will serve as your guide when you need it the most. The tips applied today can help you find a suitable alternative to your formal probate matters. So you ready? The first tip that I have as an alternative to probate is a small estate affidavit. A small estate affidavit is helpful as an alternative to formal probate where there is no will and the value of the estate is $75,000 or less. How does it work? The small estate affidavit is filed with a probate court clerk and presented to the judge. If approved, the judge signs the order and it can be used to collect assets of the estate. Okay, let's move to the second alternative to formal probate. Probating the will as a munitive title provides a streamlined probate process and is yet another alternative to formal probate. It does require that you file the will for probate. However, it is not a formal probate process because you are not appointed as executor of the estate. As such, you do not have the formal fiduciary responsibilities of an executor. Furthermore, you are not required to file a formal inventory of the estate. Probating the will as a munitive title is generally used when the main asset of the will is the homestead and all you really want to do is clear title to the house. Here's a tip. Probating the will as a munitive title offers an exception to the rule that the will must be filed within 4 years from the decedent's death. So, if it has been more than 4 years since the date of death and all you really want to do is clear title to the home, probating the will as a munitive title may be a quick and cost-effective way to go. Okay, let's go to the next alternative to formal probate, and that is filing a judicial determination of heirship. When someone dies without a will, a court may make a declaration as to the identity of the heirs and the manner and the way in which the property can be divided and distributed among the heirs. This can be done through a judicial determination of heirship. An advantage to this procedure when compared to probating a will is that it can be done after 4 years from the date of decedent's death. However, when compared to other forms of informal probate, the cost of judicial determination of heirship may be more, since all the heirs must receive notice of the proceeding and the court will require the appointment of an attorney ad litem, both which add cost to the case. So, moral of the story? When determining which is the best alternative to probate, you may need to balance the value of the estate, whether or not there was a will, and the cost of administering the estate. So there you have it. Those are 3 alternatives to formal probate. Let's recap. First, we talked about the use of a small estate affidavit where the value of the estate is under $75,000. Then we talked about the muniment title, which is an excellent choice if all you want to do is to clear title to the home which was listed in the will. And lastly, we talked about the judicial determination of heirship, where the judge determines how the property is to be divided and distributed to the heirs when there is no will. To get you started, I have set aside a free legal consultation to answer any questions that you may have. So make sure that you go over to my website and schedule a consultation. I will include a link at the end of this video as well. Remember, you don't have to go through the legal process alone. Step by step, I will serve as your guide. Call me. I look forward to meeting you.